Hey, it's your old buddy Brian Parker, bringing another good, some more of the good stuff, a good episode here. This is, in my business, good news is stretched out between a lot of neutral days, bad days, stressful days. As an attorney, you take on everybody else's problems, and so a good day is to be enjoyed and reveled in. And a good day I had recently was when I had a lawsuit that was summarily dissolved and kicked out of court by a judge that was not paying attention. And that's all I ask. Neutrality, and please pay attention to all the work I put into a file. And so then I got to appeal it because I feel so strongly about it. And we appealed it, and we won on appeal, which is a rare thing. But the way it was done, the way the court the governing court, the court above the one that kicked me, laid down exactly why the other court was so in error, and you like that. So today I appeared in front of that lower court judge for my comeuppance, for my how do you like me now, which of course I did none of that. You got to be professional at all times. You're going to see that judge in other cases, but the immature side of me wants to just scream and go, why didn't you just read this stuff 2 years ago when it was right in front of you? So with that nonsense aside, this one is called Velocity Investment Loses Appeal and Collection Lawsuit Win. An appeal, while it sends you right back to where you started, is always a win, because that's a lot of heartbreak, money, time, and energy and anxiety that goes into an appeal. So perhaps this video should be titled Appellate Linchpins. Why do I say that? I speak greatly to you about find the linchpin of the lawsuit. So what I'm going to do today, I'm going to break down quickly how I saw the lawsuit, and it's a velocity case. They're all the same. There's this huge gap in how the company that gave Velocity the debt got the debt, and who really owns the debt at the end of the day. And the circuit court appeal saw this exactly the way I saw this, the way anybody should have seen this. So in this, attached to this video at killdebt.com will be, in Word, the answer and affirmative defenses I filed at the lower court, my counter affidavit, the all-important counter affidavit that swims through the sea of litigation. In this case, it went all the way up to the circuit court appeal. My transcript of the district court ruling against us. I add that to the video because you got to see how wrong the court was. So my appellate brief in Word. So I'm going to give you my appellate brief that I took to the circuit court in Word, so you can do with it what you may. And when you file an appeal, they have a right to respond. You have a right to reply to the response. So you'll see my reply brief all in Word. The decision by the court at the circuit court. This is so important, and you're going to see why it's so cool. So I'm going to take you through, navigate you through quickly through how I saw the case. And that's important because how the Court of Appeal actually broke down the order, telling the other judge, what were you looking at, is exactly how I saw it, how I'm going to present to you. And I want to give you the energy and strength to just take a little time to follow my instructions in any case, not just Velocity. And if it is, don't deny your eyes. When I was in college, I paid for college for my food or whatever by being a store detective. So I'd sit in a heating duct or some small area watching people as they came in, and then I got so good I can figure out who was going to steal before they did. But I never believed that I was seeing someone steal. I had to put my hand on my heart and be going a mile a minute, and I go, oh my gosh, I chased that guy. So don't give in to any other outside influence. If you believe you're right, even if you got to put your hand on your heart, stick to that. Be persistent, not just in appeals, but in every day. It's you against everybody, man. It's you against the world, but believe in yourself. That's the genesis of the whole thing. So here are the players. Let's put it up. Shazam, Velocity Investments, the plaintiff, defendant, my client, Miss Debtor. The original creditors, Cross River Bank. You hear me talk about them all the time. They're flooding the fintech market with thousands of these debt buying travesties. The seller in the bill of sale so the debt was purchased, the debt was created 11/29/2020. And again, that should be up there. The seller in the bill of sale, the first document was a bill of sale, to Upstart Funding Grantor Trust 2021-1. I always call these things weird sounding trusts because they are. And that was 9/27/21. Buyer of that debt in the bill of sale was Velocity Investments, signed by Sanjay Datta. The seller of the loan was Cross River Bank, but it came after that bill of sale, 10/01/2021. And then the buyer of the loan, Upstart Network Inc., signed by Sanjay Datta again. So none of these players can say we had no idea what the others are doing because Sanjay Datta is signing all this. So the two issues that I presented the district court was, let's put it up there, editor. When I say editor, I have an editor that goes through this and gets rid of my nonsense, or at least put stuff up there for your viewing so you can understand the words if you can't understand me. The two issues, and again, remember, linchpin of this case is the same linchpin in the appeal. So is the same linchpin in your summary motion defense. It's all, the linchpin follows you. The linchpin's in the counter affidavit. So we look for the linchpin. So if you imagine a house of cards and you took one of those cards and the whole thing falls, that's what your linchpin is in litigation. Let's put that up, Shazam. How did Upstart Funding Grantor Trust, that weird sounding trust, obtain the debt to sell it to Velocity? Remember this date, 9/27/21. And if CRB, Cross River Bank, sold the debt later on October 1st, 2021 to Upstart Network, how did Upstart Funding Grantor Trust 2021 have anything to sell on 9/27/2021? And remember, both of those documents of proof were signed by the same person, Sanjay Datta. So the background for you is that this loan was agreed to on November 29th, 2020. At that point, Cross River tranches the whole thing, just securitizes it and sends it to different adopted parents, I guess you'd put it. And then I will put up for you now quickly the lawsuit linchpin. So let's go paragraph 6 and paragraph 7. Defendant, that's my client, account with Cross River Bank was serviced by Upstart Network. So they are a servicer, they're not an owner. And Cross River Bank subsequently assigned all the rights, title, and interest to Upstart Network Inc. They did, but you see there's no date here. It's called the Certificate of Loan Sale. That's purposeful. Number 7, that Upstart Network subsequently assigned the account to Plaintiff, Velocity. And Plaintiff's the current creditor. Again, no date. That's important. And by the way, there is no assignment. That's a little hint. So I advised the district court of all this in my answer, counter affidavit. I did a counterclaim and affirmative defenses. The plaintiff filed a summary motion, meaning, get this crap out of here. We win this, whether Plaintiff Parker likes it or not. And they based it on while it's a Michigan case, it's a federal court case, Livonia Property Holdings, LLC versus 128040-12976. I'll put it up there. The general is, under the Livonia Properties case, is the litigant who is not a party to the assignment lacks standing to challenge the assignment. So they weren't denying that there was assignment issues. They were saying defendant, who by the way has everything to gain and everything to lose because of the assignment, Michigan and federal law, this case says, the only people that have a right to complain about any assignment is the assignor and the assignee. So we're not going to admit or deny anything. We're just going to say under Livonia Properties, you cannot bitch and moan, defendant. And the court in that case gave us a little wiggle room. It said, while there are limited exceptions to general rule, in another case, Hamilton, they claimed none applied. So somebody was using the Livonia Properties rule. It was the Hamilton case. And Hamilton says, Livonia Properties apply here. The exceptions to Livonia Properties is the Sixth Circuit has recognized a debtor may assert a defense to a collection effort based upon an assignment, that's us, any matter which renders the assignment absolutely invalid, ineffective, or void. Again, void is not voidable. In law, void means done. There's no, it's over. Whereas voidable means, there's some room here. Either side could be right here, but it's just voidable. We're not going to turn it over. So we went in saying, and this was unique, and I didn't see why it was unique, but this is the way I said it. It appeared easy to me to tell the court Livonia Properties doesn't apply because there is no assignment. See if you can see that distinction. They claimed that this weird sounding trust, Upstart Grants of Trust Holdings, gave it to Velocity. 4 days later, Cross River Bank, who has not sent it to this weird sounding trust before that, has sent it to Upstart Network Inc. So I'm saying, I'm not arguing with the assignment, which Livonia Properties kind of would stop me. I'm saying there is no assignment at the beginning of this and at the end of that. So, and we want the district court to see this. And so the district court said, in this case, the court has reviewed all the submitted admissible document evidence. Why they, and let's put that up there, Shazam. In this case, the court has reviewed the submitted admissible document evidence. So what is it doing there when it says submitted admissible document evidence? It's in a sense claiming you are not showing me evidence that none exists. Think about that. I'm not going to say anything about these missing 2 assignments at the beginning of this and at the end, meaning when did Cross River Bank give it to the weird sounding trust to give it to the plaintiff to sue my client? And if Upstart Network has it, which their own paperwork says attached to the lawsuit, where's the assignment to Velocity Investments? It doesn't exist. So they said, we've reviewed the submitted admissible evidence. See, they're trying to get out of saying that they're looking the other way on the missing assignments. The court finds the plaintiff complaint is factually supported. It isn't. By its own support documents, the defense's main argument is the debt has not been properly assigned to Velocity Investments. That's true. The court finds that viewing the admissible evidence. So, in other words, this court is saying, I'll only look at admissible evidence. I won't look at evidence that doesn't exist in its eyes. Meaning, if there's no assignment of the debt to the Upstart Nash Grantor Trust to give it to Velocity, we're not going to discuss it. An absence of something doesn't mean it doesn't exist, but an absence of something makes something void or non-existent or invalid or ineffective. The grantor trust cannot send something it never had. So this is baloney that the court is saying, I didn't see it, so therefore it didn't happen. Well, yeah, it didn't happen. That's the point. The plaintiff, that's Velocity, is clearly established that the debt owed by defendant was properly assigned to the plaintiff. We find there's no material issue. So that's just baloney. And I, unfortunately, am cursed with one gift and the ability to read deeply into things. So I said, oh my God, he can recognize what I'm saying is true, but he refuses to listen to that. In other words, he's saying an absence of proof means it doesn't exist. So, and I can't bring something that they didn't, he's asking me to say, well, prove that they didn't assign it. Well, I can show you, and how I showed them is I broke down in a synopsis. Here's when they got the loan. Here's the first assignment, which shows a gap in between the original creditor not giving it to anybody. But I digress there. So what do? You go to the Court of Appeals. You don't let a judge think he can get away with that. I'm going to see that guy again, and I saw him today, and he knows it. You can see it. And it might not mean much to you to show a judge how wrong he is. In my profession, it's everything, because judges don't care. They only care about 2 things. That's winning the re-election and appeals. There's an ego thing, I guess, because I've asked judges, why do you care about appeal? They don't like appeals. So appeal I did. And an appeal from the district court to circuit, and this is in most jurisdictions, it's a de novo appeal. A de novo appeal means we're going to look at this, all the evidence, everything that the plaintiff is saying, everything the defendant is saying, for the first time. We're not going to use the bias of what the court said in the lower court. So they look at it again. So I introduced in my appellant brief, Shazam, this is the case of the missing assignment or transfer of a debt that Velocity failed to provide the court in proving that Miss was assigned from Cross River Bank to Velocity Investments. In the first sentence, I lay it right down what the problem is all along. Further, there's no proof of any document of support for paragraph 7. You remember paragraph 7, their own document said, let's put it up there again, because number 6 and number 7, Shazam. Number 6, the Upstart Network subsequently assigned the defendant's account to plaintiff. There was no evidence of that. So the lower court had to have read the pleadings because I shoved it in his face. They are saying we assigned it to these guys. Well, they've got to show supporting documentation. So that lower court was so wrong. So I broke down the synopsis for the court, the appeals court, the de novo court, Shazam, and showing how Cross River Bank's loan was not sold to anybody until after the bill of sale that Velocity says we own the debt, that the lower court judge says they own the debt. I just want to show you something, and you can do this in 5 seconds, right? Look at the corporate information on Upstart Funding Grantor Trust, Shazam. So that's Upstart Funding Grantor Trust, that weird sounding trust. That's showing you they incorporated 11/17/2020, dangerously close to the time when my client took a loan, if you've noticed, because it's all part and parcel of the same thing. They, Cross River Bank will create a large swath of loans. They'll have everything put in place. They'll have the tranches or the weird sounding trusts that are going to eventually get the stuff, and then when it defaults, it's dispersed. Everybody gets well off this except the defendant, who's now being sued by someone that doesn't own the debt. So that's the reason I put this up. That's the trust information. Now I go to, this is Delaware corporate information. Here's Upstart Networking, Shazam. So you can see they were created 2 years later, and even though they're, that's interesting, even though they're servicing this debt. But my point being really is they're two separate entities. And so what Velocity will do in a lot of its cases, they'll say Upstart, and they won't say which Upstart they're talking about, and they'll try to get the court to believe that it's all the same thing, therefore the assignment was proper, which it isn't clearly. So you've got to do that in your own answers and your counter affidavit. Say, here's the weird sounding trust, here's what it is, here's the delineation, here's the separate, here's Upstart Network. You do that in any case where you have a trust. Break down for the court what the trust is. Here's the bill of sale, Shazam. Upstart Funding Grantor Trust 2021 is saying on 9/27, it's selling something to the person that's suing my client, Velocity, signed by Sanjay Datta. Here is the certificate of loan transfer, and see that date, 10/01. It's 4 days later. Yeah, even though Cross River Bank, if Upstart Network Granting Trust had the right to sell anything to Velocity, it first had to get it from Cross River Bank, and Cross River Bank didn't sell anything to anyone until 4 days later, and they sold it to Upstart Network. So what is actually in your case and mine and all my other Velocity cases, this whole thing, Upstart Network holds the debt. They haven't transferred it anywhere, and you won't find any evidence that they have. And for the first time, I got a judge to realize this. So, and I showed them everything I just showed you. There's no mention of Upstart selling this to Velocity, Upstart Network. But their paragraph 7 says, Shazam, Upstart Network subsequently assigned the defendant's account to Plaintiff, Velocity LLC, and is the current creditor. Well, there's no evidence of that. So that missing evidence is what the judge in the lower court said. I don't see anything, I see no evil. If I don't see it, therefore it doesn't exist. Well, the fact that it doesn't exist means Livonia Properties doesn't apply here because it only applies to assignments that do exist. Ugh. So remember the two issues for our lawsuit? They're all the same on the appeal. How did Upstart Grantor Trust get it up there, obtain the debt, and how did CRB sell the debt to them when they didn't sell anything till 4 days later? I argued this for the summary motion again in this court. Shazam. Thank you very much, Your Honor. I'll try to go backwards. With the Hamilton case, it's actually good for the plaintiff. There's a student loan case in Department of Education that I don't go into that. They're kind of draconian. You can't bankrupt, meaning student loans. It's really tough to win a case like that, but in regards to the real use of the case, Hamilton is the general rule that a person whose debt is being challenged is challenging the assignment, can't challenge it unless they are party of the assignment. Two things are clear. My client is not challenging the assignment. She's saying there's a missing assignment. And that's the argument. But there is no assignment to Upstart, Grantor, or Grantor Trust. So how could they pass something they don't own to Velocity? And in this case, there's no link. It's missing. In order for, and this case was that, remember that, I hope you saw the deposition I did of the debt collector attorney? That's this guy, Mr. Johnson, Bradley Johnson. And I say he just focused right on the bill of sale, and it says Upstart is giving it to Velocity on September 27, but nobody is giving it to Upstart Funding Grantor Trust. So even the Hamilton case, which is Livonia Properties, recognize an exception to the general rule, and the exception is, if you can just point that out, here you go, the assignee's lack of title. So I should have won that, and the judge pretended like he didn't hear any of it. No evidence of assignment to Grantor Trust, no evidence of anything to Velocity from Upstart. So here is how the court at the Court of Appeals ruled. I'm just going to go straight to that, and this is the point of that video. Here's the first paragraph, Shazam. Whereas the case of Livonia Properties provides that a debtor may assert a defense to a collection effort based on assignment, any matter that renders assignment absolute valid, invalid, ineffective, or void, he's essentially recognizing that. When I heard him say that in the actual hearing, I'm like, oh, I'm lost. He's focusing on that. But in his order, he says, Defendant Appellate asserted that the certificate of loan transfer purportedly transferred the debt of my client from Cross River Bank to Upstart, whereas me asserted that the bill of sale purportedly transferred the debt from Upstart Funding Grantor Trust to Velocity, September 29th. I don't know why he said 29th, as opposed to the October 1st to Upstart. Whereas Defendant Appellant asserts that the assignee, Velocity Investments, lacks the title to the debt owned by my client based on the following. There's no record in the chain of title of anything being transferred to the Upstart Funding Grantor Trust. And two, regardless, any transfer of the debt prior to October 1st is ineffective. He's using the word ineffective because that's part of the exception to the rule that a person can't complain about an assignment unless they're a party to it. It is further ordered that the matter is remanded to trial court, because the reasons set forth above and those placed in the record, the court determined that a genuine issue of material facts exists as the claim of title of the debt that Velocity Investments purportedly acquired by assignment. So the appeals court saw it for what it was. I had to wait 2 years for the truth to come out, the reality of it all. And so after a de novo appeal where the court is looking at it for the first time, they could see it my way. It took probably 3.5 hours of several hearings, in which time Bradley Johnson showed up, argued absolute nonsense. He then left the firm. His owner came in. The owner of the firm came in to argue against me, and the court said, no, bring Bradley Johnson. So Bradley had moved on to another company. He made Bradley Johnson come in and argue against me. I thought, I'm losing this. They just want to set the record. And I think the court saw it for what it was and just wanted to spank those guys for doing such fiction and going so hard on my client. So attached to this victory against Velocity will be in word at killdebt.com, the counter affidavit, the answer and affirmative defenses at the trial court, my transcript at the district court showing exactly the way I'm telling you what I told the court that they looked the other way on, the appellate brief of my client in word, the reply brief of my client, and the decision by the court, which just made me so happy because there's so few really good days. And when the right thing goes the right way, it makes you happy. Even though it's not my case, I take a personal, I have personal feelings about every case I have, because at one point that was me, the person I'm representing. And when I see wrong happening and judges who are hired to be mediators, meaning neutral, look the other way and make BS decisions like that trial court did, sorry, that's my opinion, I'm allowed to have an opinion. I want justice, and justice we got. It was delayed, and today I got to stand in front of that judge that did the wrong stuff. And I kept my cool. Got to be mature, got to be an adult. The gray hair is there for a reason. But just remember, the linchpin of the lawsuit is the linchpin of your appeal. I hope some of this was clear and it's helpful. And just look at the documents attached to killdebt.com. Again, don't forget, Natalie's got that whole documents vault for everything you want, for every form you want. Hopefully, just add your state law and your facts. Killdebt.com is killing it right now. It's quite popular. Hope it helps you. Brian Parker, thank you very much.